Buckle up for a wild ride into the heart of domestic turmoil. In State of Texas versus Joseph Chasen, we're unpacking a chilling aggravated assault case where Chasen, a father with a turbulent past, pleads guilty to cutting his wife with deadly glass shards during a booze-fueled fight. Defense pushes for probation, highlighting his family support and low reoffending risk, but the judge digs into his denials, criminal history, and failed vows. With kids witnessing the chaos and a pattern of violence, will mercy prevail or will prison walls close in? Get ready for raw confrontations, hypocrisy calls, and a verdict that slams home the cost of unchecked aggression. Stay tuned, this one's a gut puncher.
Weren't you? You weren't drinking that night? You weren't intoxicated that night? You didn't even wake? Okay. But number next, you threatened to cut somebody with shards of glass. 392. I mean, that's just 43 is called. You are Department Joseph Chasen.
Yes, sir.
Present with your attorney, Mr. Lane, and the state's attorney. Earlier, you pleaded guilty to this indictment in this case, alleging aggravated assault, a second-degree felony. A pre-sentence report has been prepared. Have the parties had an opportunity to review it? And are there any corrections or changes to it?
Defense has, and no correction.
We have, and there are no objections or changes.
It's made a part of the record for all purposes. The defendant just pleaded to paragraph 1, I believe.
That's correct, Judge.
So the agreement here is whatever sentence shall not exceed a cap of 7 years. So no less than 2, nor more than 7 years. The defendant can also be placed on deferred or unadjudicated probation for up to 10 years only. Regular probation, I believe, is not an option under this circumstance, under the allegations. We're going to start with Mr. Lane. You may go forward, sir.
Your Honor, we're asking the court to defer all proceedings and place Mr. Chasen on probation for a term of years, and that he be required to fulfill the conditions of the plan set out in the probation report. It does note that he is a low risk of reoffending. Your Honor, Mr. Chasen has been married for 16 years to the victim in this case. They have had altercations in the past. They've led to police being called, charges being dropped on both sides. And it just has turned out to be a toxic relationship. Mr. Chasen has, he was actually bonded out by the victim in this case. She was the first one to notify the bail bondsman to try to get him out. He does, with the 2 children, he has to pay child support. He just got a new job as a carpenter, doing some roofing and remodeling. He cash apps child support payments as best he can through his sister, who's very helpful. He does have a relationship with his 2 children. They are legally divorced over in Louisiana. That visitation at this time is supervised. And of course, the court knows if he does violate a condition of probation, if he doesn't go to anger management, he could get 180 days as a condition of probation. He could be sentenced to 20 years in prison. I've submitted to the court 17 support letters from his family, his siblings. All of them have stated that he is charitable, that he is a family man, that he is helpful, most importantly to his mother, whose ailments require daily help from Mr. Chasen. He is there. He remodeled their house along with another sibling. The letters also indicate that he's very encouraging to his siblings to stay in school, to stay at their job, fight the good fight, and that he had done what he could to give to his siblings what he had. He obviously needs to be away from his children's mother. They, as you've seen in the court's experience, they fight and get back together and fight and get back together. And I submit to you that's what happened here. But other than that, there hasn't been aggression with anybody other than his spouse, is my understanding.
Of all people on the planet, to make the exception to that rule, your spouse. So everyone else on the planet, you're going to treat well, but it's your spouse that you feel like needs the living hell of a life. I mean, didn't you pay attention to your vows when you were married? Didn't you? Or were you intoxicated during that time like you were at this event?
Whenever we got married, she wasn't on drugs.
Sir, you were intoxicated. Here's what police woke you up and asked what happened. You were considerably intoxicated and you couldn't even respond. How would you even know what was happening? You're catatonic. You ready? Weren't you? You weren't drinking that night?
No,
you weren't intoxicated that night?
I drink that beer.
You didn't even wake. Okay. Officers woke you up. What happened? They asked. You appeared to be considerably intoxicated and would not respond. These are police officers who deal with these situations every day. You don't think they can tell somebody's intoxicated or not? Okay, hold on. Let's see. You were on, let's see, probation, violating a protective order in 22. I guess this was involving the same lady. In 04, underage driving under the influence. We started out early, wasn't even an adult, and you were driving intoxicated. Let's see. Aggravated flight from an officer. 1 year hard labor for that in 05. Disturbing the peace by appearing in an intoxicated condition in 16. Pleaded guilty to that. Driving while intoxicated, second. That's a disposition unknown. Disturbing the peace by loud and profane language. That was dismissed. Simple assault, dismissed. Disturbing the peace by time. You keep getting arrested for stuff. And really, convictions are what's important, but there's so much smoke here, it's got to be fire. You're the one with this record. How many times have you been arrested? Can you even guess? Let's see. And the aggravated battery here in 17, domestic violence. Who was the victim in that case? Your wife? Yeah. Yeah. The lady who's so evil that you're saying is so evil, where you're completely innocent. So you pick up 1 year home incarceration, but that was revoked the following year. Let's see, domestic violence with a dangerous weapon, public intimidation. Wow. What a charge there, huh? In 2019, domestic abuse, battery with child present. In 21, the judge issued an order prohibiting you from possessing or purchasing a firearm. Well, we can read between the lines what that was all about. So you're the innocent one. What else?
Your Honor, he's not an evil or mean person that I see. I mean, we see him when they just like to beat on whoever they can, and the weakest ones is the. He doesn't seem that way to me.
I'd say he has a consistent pattern. You want to call, you don't need, you can label that evil or not, but there is no crime for being evil. I wish people weren't, but there are crimes for not following the rules of law, which he has been consistent in doing.
They have taken the steps. They have officially divorced. There is a visitation order in effect in Louisiana, which provides for protection of the victim in this case, and even children, if so. And I believe the restrictions in probation here can also provide her the safety and the community. And I don't believe he'll reoffend, Your Honor. He has a very strong family. They've been in constant contact with me, as has he. He's back to work. I think he can do it.
Told the probation office that he drinks daily, but does not have a problem. During the pre-sentence interview, the defendant did not accept responsibility and denied assaulting the victim. I'm going to remind you here, like all cases that we go over we've done this thousands of times. And you signed a document under oath that states, in light of your statement here, that you're not taking responsibility. And here's my favorite one. If it wasn't for my record, I would have gone to trial. That's just pathetic. I did not touch her, but yet under oath, you signed a sworn document that I am mentally competent to enter my plea, which is freely and voluntarily made. I've read the indictment. The attorney has explained it to me. I have committed each and every allegation charged. I am guilty of the offense and any lesser included offenses alleged against me. I swear all of this is true. So help me God. What you pleaded guilty to that we went over was that you intentionally and knowingly and recklessly caused bodily injury to Maggie Chason by the use of a deadly weapon, namely glass, by cutting her. And in the manner of its use and intended use, glass shards are capable of causing serious bodily injury.
Hold on, this is getting heated. The judge is grilling Chasen on his wedding vows and intoxication, pointing out the irony of treating everyone else well, but allegedly brutalizing his spouse with glass shards, classified as a deadly weapon under Texas law, elevating this to second-degree felony aggravated assault, punishable by 2 to 20 years. Defense argues for deferred adjudication probation, citing low reoffending risk per the PSI report, 17 support letters praising his family help, new job as a carpenter, child support efforts, and supervised visitation post-divorce. But the judge exposes Chasen's rap sheet: underage DUI, aggravated flight, multiple DWIs, disturbing the peace, revoked home incarceration for domestic violence, firearm bans, smoke signaling fire, and a pattern of abuse. Chasen denies intoxication that night despite police reports of him being catatonic and claims the relationship was toxic both ways. This highlights the emotional stakes: kids witnessing violence, a cycle of fights and reconciliations. Hypocrisy alert, swearing love but wielding shards, brutal. Who do you side with? Defense's redemption plea or judge's accountability push? Would probation reform him or is prison the only safeguard? Stick around.
And that you cut her, a member of your family, with the glass. Signed, your name, I swear to God, all that's true. So, are you lying today, or are you lying when you looked at me in the eye under oath and committed perjury then?
Yes, sir.
No, sir, what?
No,
Oh, but you admitted you did it all under oath.
yes, sir.
Is that what you're standing by,
Sir.
sir?
Yes, sir.
Sounded differently a few minutes ago. You weren't guilty of it. Let's stay absent.
Judge, I don't feel that probation is warranted, number one, because he doesn't truly accept responsibility for his actions. Number two, we've basically been trying to make the complainant out to be the bad person. And the court is focused a lot on that, and I appreciate that. I want to highlight the fact that his child was present at this occasion as well. 7 years old. She was listed as one of the witnesses as well. And apparently, when looking through his history of the 6 different domestic matters that he was arrested on, apparently a child was present at one in 2019. So I disagree with his lawyer. I feel that his conduct is consistent. He chooses to drink on a daily basis. He makes bad choices. Obviously, when he's drunk, that's apparent from the 2 pages worth of criminal history that we have here. He's not eligible for probation from a jury. That's why Mr. Lane convinced my trial partner to allow him to cap this agreement to make the pitch that he did today. If he, however, had maybe had some different statements to your probation officer, he might have been off on a stronger foot. But the reality is he doesn't accept responsibility. His kids have already seen too much of this. His wife at that time is nothing more than the victim, and certainly not the scapegoat in this matter. The state was at a point when this case was on the trial docket suggesting 10 years. It was only through good lawyering by Mr. Lane that we conceded and did this cap agreement here. I agree with Mr. Laird, and what's appropriate here is 7 years.
All right. Rebuttal, anything else?
Well, Your Honor, we disagree with that. We think that the conditions of probation will provide the protection for.
But he's failed in probation before.
Your Honor, if the court is inclined to place him in prison, he did 1 year, actually 10.5 months on this previous deal. We would ask the court to go closer to the minimum condition. He doesn't care. That is going to provide, well, the deterrence that the system requires. And
how about protection in the community and in the home from this man's repeated disturbing behavior of violence and in constant intoxication?
I understand. And Mr. Jason would like to address the court.
Yeah. What else would you like to say?
I mean, if probation, I even mess up, and also always manage.
You made a promise when you were placed on probation the last time that you made a promise to the court and you failed that, right? All courts make have the same set of documents essentially, and you make a promise. I swear I will follow all the terms and I know I can be revoked, and that's what happened.
Do anything I have to do.
You know what you need to do is live in peace with the people you quote, that you state and purport to say that you love and care for. I can't imagine anyone, much less someone I care for and profess love as a spouse like mine or yours, that you would quite naturally be in a constant state of intoxication as a role model, which is poor. But next, you threaten to cut somebody with shards of glass. I mean, that's just, that's a twilight zone of a life. That doesn't have anything close to love and honor and commitment and loyalty. You betrayed those vows. You betrayed the laws. You defied the laws, and you committed a crime. And it's a violent crime. And it begs the question: if you would do this for someone you love, you say you love, if you do this to them, what would you do for somebody who you decided you needed to harm, who you had no association with? It's a frightening thought. You have pleaded guilty voluntarily. You were mentally competent to do so. You understood the consequences of pleading guilty. There's sufficient evidence supporting a guilty plea. State's Exhibit 1 admitted here in the plea hearing to find you guilty beyond a reasonable doubt. And I now find you guilty beyond a reasonable doubt. I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 6 years. There will be an affirmative finding on the judgment rendered that a deadly weapon, namely glass, was used in the commission of this offense, and that will be rendered on the judgment.
Boom, the state fires back hard. They slam Chasen for dodging responsibility, admitting daily drinking without seeing it as a problem, and denying the assault despite his sworn guilty plea, classic perjury territory, as the judge calls out his signed confession to intentionally cutting his wife Maggie with glass, causing bodily injury in a family violence context. State highlights kids' exposure. A 7-year-old witnessed this nightmare, echoing a 2019 domestic battery with child present. With 6 domestics in his history, they argue consistency in bad choices, ineligibility for jury probation due to the deadly weapon finding, and push for the 7-year cap, down from their initial 10-year demand. Defense rebuts, begging for minimum prison if no probation, citing prior 10.5 months served as deterrence. But the judge's epic rant nails it. Betraying vows, failing past probation, living in a twilight zone of violence. What if he harms strangers? This amps the drama, exposing addiction's grip and cycle of abuse. Chilling question: if he'd do this to loved ones, what's next? Do you think his family support outweighs the risks? Would you risk probation on someone with revoked history? The sentence drops now. Prepare for impact. In this harrowing case of State of Texas versus Joseph Chasen, a guilty plea to second-degree aggravated assault with a deadly weapon, glass shards used to cut his wife amid intoxication, unravels into a sentencing showdown. Despite defense's plea for deferred probation, backed by family letters and low-risk assessment, Chasen's denials, extensive criminal history of domestics, DWIs, and failed probation seal his fate. The judge, emphasizing betrayal of vows and child witnesses, rejects mercy and imposes 6 years in TDCJ with a deadly weapon finding barring future firearms. Key takeaways: accountability trumps excuses in domestic violence. Patterns of abuse demand intervention to protect victims and society. This underscores the system's role in breaking cycles, but raises questions on rehabilitation versus punishment. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.